a landmark ruling. Supreme Court shakes up FIR registrations. The Supreme Court of India has dropped a bombshell, a game changer. This is about your rights, the rights of every citizen. We are talking about the First Information Report, the FIR, the first step to justice. The highest court has drawn a line in the sand between the old and the new. This is about Section 156, subsection 3 of the Criminal Procedure Code, and Section 175, subsection 3 of the brand new Bharatiya Nagarik Suraksha Sanhita, the BNSS. One allows for swift action, the other demands accountability. This isn't just legal jargon, folks. This is about real people, real cases. Imagine a scenario where someone, let's say a helpless woman, approaches the police. She has a complaint, a serious one. But the police, for whatever reason, refuse to file an FIR. What can she do? The Supreme Court has spoken. This ruling is going to send shockwaves through the system. It's a wake-up call for those who thought they could get away with anything. The message is clear. No more shortcuts, no more hiding behind technicalities. The days of unchecked power are over. The time for accountability is now. Understanding the old guard. Section 156, subsection 3 of the CrPC. For years, Section 156, subsection 3 of the Criminal Procedure Code has been the go-to tool for seeking justice. This section empowers the magistrate, the protector of our rights, to direct the police to register an FIR. Sounds simple, right? But here's the catch. It didn't always ensure fairness. Imagine this. You are a victim. You go to the police, but they refuse to even listen to your plea. You approach the magistrate, hoping for relief. Under the old system, the magistrate could simply tell the police to register the FIR, often without even hearing their side of the story. This might seem efficient, but it had its flaws. What if the police had a legitimate reason for not registering the FIR? What if there was more to the story? This lack of scrutiny sometimes led to misuse. False cases, personal vendettas. The system was vulnerable. The magistrate, under pressure to deliver justice quickly, sometimes ended up acting as a rubber stamp. The new sheriff in town, Section 175, subsection 3 of the BNSS. Enter the Bharatiya Nagarik Suraksha Sanhita, the BNSS, with its own set of rules. Section 175, subsection 3, the star of today's discussion, changes the game completely. It brings in a much-needed layer of accountability. No more shortcuts. Here's how it works. Let's go back to our example of the woman seeking to file an FIR. Under the BNSS, if the police refuse, she still has the magistrate as her safeguard. But now the magistrate has to hear both sides. The police officer has to explain why they refused to register the FIR. Was there a lack of evidence? Were there inconsistencies in the complaint? The magistrate is now obligated to listen. And it doesn't stop there. The magistrate can't just issue an order based on whims and fancies. They have to give reasons, a reasoned order, explaining why they decided to direct the police to file the FIR, or why they agreed with the police's decision. Striking a balance. Ensuring justice and accountability. This is a landmark judgment. The Supreme Court has sent a clear message. Justice delayed is justice denied, but justice rushed can be justice compromised. Section 175, subsection 3 of the BNSS is not about making it harder to file an FIR. It's about making the process more robust, more transparent, more accountable. It's about ensuring that every voice is heard, every story is considered, and every decision is justified. This is not just about the police or the magistrates. This is about the soul of our justice system. It's about restoring faith in the very institutions that are meant to protect us. The Supreme Court has spoken. The message is clear. Let's hope the system listens.